Okay, now we're going to look at the bankruptcy problems and explanations. And these are the problems we'll look at in the areas of overview, bankruptcy administration, bankruptcy liquidations, and reorganizations and adjustments. So the first problem, problem 1, is in the overview section, and it's dealing with bankruptcy courts. And the question asks, federal courts have jurisdiction over bankruptcy proceedings and bankruptcy courts. It gives you 4 options. So bankruptcy courts are specialized federal district courts, so they're at the lowest level of the federal court system. The courts preside over administration of bankruptcy estates, and orders and judgments from a bankruptcy court are reviewed by the district court judges or by 3 bankruptcy judges together as a panel. And appeals after the review by the above can be taken to a circuit court of appeals. So the question is asking bankruptcy courts. Answer A are Article 3 federal courts, the judges of which have life tenure, and bankruptcy judges do not have life tenure, as do district and circuit court judges, and Supreme Court justices. Answer C says bankruptcy courts have full powers to decide collateral issues affecting the debtor, such as contract and tort claims. And that's incorrect, because bankruptcy courts only have jurisdiction to issue final orders and judgments with respect to bankruptcy proceedings. Answer D, bankruptcy courts are presided over by trustees in bankruptcy who serve 14-year terms. Bankruptcy judges who preside over the court proceedings are appointed for 14-year terms, so they're presided over by judges, not trustees. So the correct answer is B, bankruptcy courts are special administrative courts under the authority of the U.S. District Courts. Now, problem 3 is also in the overview section. The question states, Emma's creditors filed an involuntary petition in bankruptcy against her. An order for relief was entered and a trustee was elected by the creditors. The trustee wanted Emma to file a list of creditors, a statement of her financial affairs, and other information. She was upset by being forced into bankruptcy and refused to cooperate. And the question asks, which of the following is true? So the Bankruptcy Code requires a debtor to file information as to his or her debts, property, income, and other related matters, regardless if the petition was voluntary or involuntary. And a debtor has a duty to cooperate with the trustee, including surrendering his or her property and any pertinent records. The court can refuse to discharge a debtor if he or she refuses to obey any lawful order. So it asks, which of the following is true? B is incorrect. Emma does not have to cooperate since the petition was involuntary, and in fact she does. It doesn't matter whether it was voluntary or involuntary. C is incorrect. The creditors must provide this information. Now, once the creditors file the involuntary petition, the trustee, who is either selected by the creditors or appointed by the court, will require that of the debtor. And D is incorrect, because Emma is a citizen of a state. The federal court cannot issue sanctions against her. And bankruptcy courts are federal courts. So once an order is entered, the debtor is subject to the jurisdiction of the bankruptcy court, and she can be held in contempt or denied a discharge. So answer A is correct. Failure to provide the requested information may prevent her discharge. Problem 8 is in the area of bankruptcy administration, and the question asks, to file for bankruptcy under Chapter 7 of the Federal Bankruptcy Code, an individual must, and it gives you 4 options. So any person with a debt may file a voluntary petition under the respective chapter of the code if they are an eligible entity. And by eligible entity, we're talking about some chapters of the bankruptcy code apply only to individuals, applies only to farmers or to fishermen, that type of thing. So that's what they're talking about. So answer B says be insolvent. Insolvency is not required to file a voluntary petition. It is only necessary that the person have a legal obligation. C says be indebted to more than 3 creditors. And C is incorrect, because the number of creditors thresholds apply only to involuntary petitions filed by creditors. And again, this was a voluntary petition. And D is incorrect. Have debts in excess of $13,475. And again, the amount of debt thresholds apply only to involuntary petitions. So have debts of any amount. Answer A is the correct answer. Problem 15 is also in the area of bankruptcy administration. The question asks, which of the following requirements must be met for creditors to file an involuntary bankruptcy petition under Chapter 7 or Chapter 11 of the Federal Bankruptcy Code? And an involuntary petition may be filed by one or more creditors who have unsecured claims of at least $14,425 if there are fewer than 12 creditors. If there are 12 creditors or more, then 3 or more creditors who have unsecured claims of at least $14,425 in the aggregate must sign the petition. So the question is saying which of the following requirements must be met. B talks about the debtor has not been paying its bona fide debts as they become due, and that's incorrect. The petition also may be filed if a custodian, assignee, or general receiver took possession of the debtor's property during the 120 days preceding the filing of the petition. Answer C states there must not be more than 12 creditors, and it's incorrect because 3 unsecured creditors may join in filing the petition if there are 12 or more creditors. And answer D states at least one fully secured creditor must join the petition. A secured creditor is not required to join the filing of an involuntary petition. So answer A, the debtor must owe at least $14,425 is required in order to file an involuntary petition under Chapter 7 or Chapter 11. Okay, problem 26 is also a bankruptcy administration question, and the question asks, the Bankruptcy Code provides that a debtor is entitled to claim as exempt property the right to receive, and it's asking Social Security benefits and disability benefits, and certain assets in the state are created by the filing of a petition. Certain assets in the state created by the filing of a petition are exempt from creditors, and that includes Social Security benefits, disability benefits, alimony, child support, and certain pension benefits, and that gets into a little bit more detail than we need to at this point. So the correct answer would be C, because that's the only one that shows both Social Security and disability benefits are exempt from creditors. Problem 32 still falls within the bankruptcy administration section, and the question is Bert Burton's business was faltering and the creditors were beginning to demand immediate payment. Burton's brother had recently set up a new corporation for real estate investments with the intent to save some of his assets. Burton transferred them to the new corporation with an understanding that Burton would receive stock after resolution of his financial problems. 5 months later, Burton filed for bankruptcy. Will a trustee who has discovered the transfer be able to recover the assets? And first we must look at what is the definition for a fraudulent conveyance, and that's one made with actual intent to hinder, delay, or defraud creditors. And any fraudulent conveyance is void if made within 2 years before the petition is filed. So if we're looking at the 4 options, answer A says the trustee cannot recover the assets because the transfer was more than 90 days before the petition was filed in bankruptcy, and that's incorrect because he can recover any fraudulent conveyance transferred within 2 years prior, and this fell within that at 5 months. Answer C states the assets can be recovered as a preferential transfer, and that's incorrect. The transfer was not a preferential transfer but actually a fraudulent conveyance. A preferential transfer is made when one creditor is preferred over another. And answer D states the assets cannot be recovered because the corporation is a separate legal entity. And that's incorrect because a fraudulent conveyance is voidable no matter to whom the transfer was made. So it didn't matter whether the corporation was legally operating. So answer B, the assets can be recovered as a fraudulent conveyance, is the correct answer. Problem 36 deals with bankruptcy administration, and it's looking at the facts at the top of the page, which states that on August 1, Hall filed a voluntary petition under Chapter 7 of the Bankruptcy Code. Hall's assets are sufficient to pay general creditors 40% of their claims. The following transactions occurred before the filing. On May 15th, Hall gave a mortgage on Hall's home to National Bank to secure payment of a loan National had given Hall 2 years earlier. When the loan was made, Hall's twin was a National employee. On June 1st, Hall purchased a boat from Olson for $10,000 cash. On July 1st, Hall paid off an outstanding credit card balance of $500, and the original debt had been $2,500. The question is asking the credit card payment made by Hall on July 1st was, and some of the facts in these legal questions or these law questions, they tend to give you extraneous information that is not pertinent to the question, such as Hall's twin was a National employee. They're trying to get you sidetracked onto other issues like conflict of interest, and that's not an issue here. So if we look at the law regarding preferences, a preference voidable by the trustee is a transfer of the debtor's property to or for the benefit of the creditor. on an antecedent debt, which means a debt that was in existence before the filing. It was made within 90 days before the filing. It was made while the debtor was insolvent, and that enables the creditors to receive more than he or she would have in the bankruptcy proceeding. But an exception to this is a payment of less than $600 on a consumer debt within the 90-day period. So the question is asking you about the credit card payment. So answer A says preferential because the payment was made within 90 days of the filing of the petition. The transfer was a remittance of up to $600 on a consumer debt, so it doesn't fall under that. Again, answer B, preferential. It's not preferential because it was under $600 on a consumer debt. D says not preferential because the payment was less than 40%, and it's incorrect because the percentage of the original debt remitted is not determinative of whether the exception to voidability of the preference applies. The otherwise voidable transfer may not be set aside by the trustee if it is less than $600 and made on a consumer debt. So answer C is the correct answer. It's not preferential because the payment was for a consumer debt of less than $600. And problem 41 is our last problem in bankruptcy administration, and the question is asking which asset is included in a debtor's bankruptcy estate. And the rule that applies here is any asset in which the debtor has a legal or equitable interest at the date the proceeding began is included in the estate. It includes property acquired by the debtor within 180 days after filing the petition if the property was acquired by inheritance, by will, or intestate succession as proceeds of an insurance policy from a property settlement in a divorce proceeding. So the question specifically is asking which asset is included in the bankruptcy estate. And answer B is an inheritance received 270 days after the petition was filed. And inheritance must be received within 180 days, so it's not included. C states property from a divorce settlement received 365 days after the petition was filed. And that is incorrect because the divorce settlement must be within 180 days of the filing. And D is incorrect. Wages earned by the debtor after the petition for relief was filed are not included in the estate. So answer A is correct. Proceeds from a life insurance policy received 90 days after the petition was filed because, again, it's within 180 days and it's one of the items, proceeds of an insurance policy. With bankruptcy liquidations, and the question asks, on June 9th, Amy Aker transferred property she owned to her son. The property was collateral for Aker's obligation to Simon. Aker transferred the property with the intent to defraud Simon. On July 7th, Aker filed a voluntary bankruptcy petition. Which of the following statements is true? So, again, Amy transferred property that she owed money to Simon, and the property was collateral, and she did it in order to avoid the property becoming part of the bankruptcy estate so she could defraud Simon. So under the bankruptcy code, the court will deny a general discharge of a debtor's liabilities if within 2 years of filing the petition for relief, the debtor transfers property with the intent to hinder, delay, or defraud any creditor. So if we're looking at the specific answers, answer A says only Simon's debt will be accepted from Aker's discharge in bankruptcy. The fraudulent act will lead to a denial of a general discharge of the debtor's liabilities. Answer C states the transfer will be set aside because it constitutes a preference. One of the elements of a preferential transfer is the transfer of property to a creditor, and in this case, Aker's son was not a creditor. And D states Aker will receive a discharge in bankruptcy of all debts, and she will be denied a discharge in bankruptcy of all debts because of the transfer to her son in order to defraud Simon. So answer B is correct. She will be denied a discharge in bankruptcy. With reorganizations and adjustments, and this is under Chapter 11 reorganization. A reorganization plan must designate classes of creditors' claims and owners' interest, state the treatment to be given each class, indicate which classes will or will not be impaired, allow for equal treatment of the members within a class unless they agree otherwise, and provide for an adequate method for payment. If the debtor is also a corporation, the plan must protect voting rights. It must state that no non-voting stock will be issued, and it requires that the selection of directors and officers be effected in a manner to protect the parties' interests. So the question states a plan of reorganization under Chapter 11, and it's trying to determine which one would apply. Answer A is incorrect because only the debtor may file a plan within 120 days, and A states may be filed by any party in interest for 120 days after entry of the order for relief, so it can only be filed by the debtor. And answer B says must be filed by the trustee and approved by the creditors within 180 days after entry of the order for relief. And that's incorrect because only the debtor may file the plan within 120 days after entry of the order for relief unless a trustee has been appointed. And if the creditors do not approve of the plan within 180 days of the entry of the order for relief, any party in interest may file a plan. Answer C states must treat all classes of claims and ownership's interest equally, and that is incorrect. The plan must be fair and equitable, but all classes need not be treated the same. However, no party may receive less than the amount that would have been distributed in a liquidation. So answer D is correct, must treat all claims or interest in the same class equally. So all claims don't have to be treated equally, but all claims or interest in the same class must be treated equally. Okay, problem 66 is also dealing with reorganizations and adjustments, and the question is specifically asking about a reorganization under Chapter 11 of the Federal Bankruptcy Code. Requires all of the following except. So Chapter 11 allows for payment of creditors and restructuring of the debtor's finances. It also allows the business to proceed in operations, and it enables restructuring instead of liquidation. So answer B says the filing of a reorganization plan, and that's not correct. C, confirmation of the organization plan by the court, and that's incorrect. Physical plan must be confirmed by the bankruptcy court. And answer D says opportunity for each class of claims to accept the reorganization plan, and that's incorrect because the plan that the bankruptcy judge finds is fair and equitable may be confirmed without approval of all classes of creditors, and that's what's called the cram down plan. So answer A is correct. A reorganization under Chapter 11 of the Federal Bankruptcy Code requires all of the following except liquidation of the debtor, because again, it's a reorganization plan, not a liquidation plan. And our last problem is 72, which deals with reorganizations and adjustments, and the question asks, which of the following statements best describes the effect of the entry of the court's final decree? And again, if we're looking at Chapter 11 reorganization, an entity that is granted Chapter 11 status will be discharged from its debts and liabilities that occurred prior to the confirmation of the plan, except as provided for in the plan of reorganization, by an order of confirmation, or by the bankruptcy code. So the effect of a confirmation is to make the plan binding on all parties and to grant the debtor a discharge from claims not protected by the plan. So the question is asking which of the following statements best describes the effect of the entry of the court's final decree. Answer A states Strong Corp will be discharged from all of its debts and liabilities. And we're looking at the information above. Strong Corp filed a voluntary petition in bankruptcy under the reorganization provision of Chapter 11 of the Federal Bankruptcy Code. A reorganization plan was filed and agreed to by all necessary parties. The court confirmed the plan and a final decree was entered. So which of these best describes the effect of the court's final decree? Answer A states Strong Corp will be discharged from all of its debts and liabilities. The debtor will not be discharged from all of its debts, so this one is incorrect. A Chapter 11 bankruptcy proceeding allows a business to continue to operate after it has been reorganized and has restructured its debts and finances. Answer B states Strong Corp will be discharged only from the debts owed creditors who agreed to the reorganization plan. The confirmation of a reorganization plan binds all parties in interest, and creditors may be forced to accept a reorganization plan approved by the court, so that answer is incorrect. C, Strong Corp will be discharged from all of its debts and liabilities that arose before the date of confirmation of the plan. And answer C is incorrect because under a reorganization plan, the debtor may not be discharged from certain debts prior to the confirmation of the plan if the court finds it is inequitable to discharge those debts or if a discharge of debts is prohibited by the code. So answer D is the correct answer. Strong Corp will be discharged from all the debts and liabilities that arose before the confirmation of the plan, except as otherwise provided in the plan, the order of confirmation, or the code. That concludes our problems for this section.